Thank you, Cairn Corlea. I'm happy to take this opportunity to update the House on the appointment by the Government of members of the judiciary. Over the last century, one of the great successes of the modern Irish state has been the judiciary, which has consistently acted in a robust and independent fashion and earned the respect of fellow judges in Europe and around the world. Since I was elected to this House, and especially since I've had the honour of serving as Minister for Justice, I've been acutely conscious of my overriding duty to uphold and to vindicate the independence of the judiciary. And as Minister for Justice, I will continue to do so throughout this debate. I'm happy to set out the details of this appointment for the information of deputies. However, unlike previous ministers who have answered questions in relation to judicial appointments, I come to the House today as a number of members have put forward a motion of impeachment. It makes it all the more important that everyone in this House today is mindful of their responsibilities. It is incumbent on all of us to uphold the independence and integrity of the judiciary and to not do or say anything which could undermine the courts or any sitting judge, or indeed undermine the separation of powers. We do not have to look too far across Europe to see instances where the independence of the judiciary is questioned. I have participated in the European Union meetings where this very issue was discussed many times. It is important to first set out the process by which judges are appointed under the Constitution and the law. I know many members will already be familiar with this process, given the lengthy debates in this House in recent years over the judicial appointments legislation proposed by the last government. Appointments to the judiciary are made in accordance with Articles 13.9 and 35.1 of the Constitution by the President, acting on behalf of the Government. This is a constitutional function that cannot be transferred, it cannot be delegated. The Constitution prerogative to advise the President on judicial appointments lies with the Government alone. The Government takes this responsibility seriously, and our objective at all times is to propose the best person to fill each judicial vacancy, and I can assure the House that that was also the case when the Government decided to nominate Justice Seamus Wolfe to the Supreme Court. As I outlined to the House in replies to parliamentary questions earlier this week, it has been the practice to maintain a vacancy in the Supreme Court due to the reduction achieved in waiting times in that court in recent years. However, this is of course kept under review. In this particular case, the Chief Justice wrote to the then Minister for Justice on the 4th of February this year, requesting that the Supreme Court vacancy arising from a retirement in June of 2019 be filled. He cited emerging pressures, including the establishment of the Cervical Check Tribunal. As he was obliged to do so under law, the then Minister for Justice wrote to the Judicial Appointments Advisory Board, or JAB, on the 17th of February 2020. In keeping with the usual practice, the Minister asked the Board to furnish him with nominations for this vacancy and the name of each person who had informed the Board of his or her wish to be considered for appointment. The then Minister also responded separately to the Chief Justice, stating that this request of JAB did not presuppose the filling of the post. It was to facilitate the procedure should a decision be taken to make an appointment at whatever point in the future that the vacancy might be progressed. Indeed, the only judicial nomination made during the period of government formation was to the post of President of the High Court, and as this is a senior position, has broader statutory functions, it was done. It should be noted that this appointment on the 18th of June, a week before government was formed, then resulted in the second vacancy on the Supreme Court. It also might be helpful to explain that the Judicial Appointments Advisory Board, or JAB, is an independent board. It was established under the Courts and Courts Officers Act 95 to identify persons and inform the Government of the suitability of applicants for appointment to judicial office. In line with the Cabinet Handbook, between the 11th and 14th of July, I informed the Taoiseach Taoiseach Minister Ryan and the Attorney-General of my intention to propose Seamus Wolfe for the position, following which I brought a memorandum for the Government's consideration on the 15th of July last, recommending a name to Cabinet for appointment by the President. In this case, the recommendation was in line with the recommendations of JAB, which is chaired by the Chief Justice, includes the Presidents of the four courts, as well as the Bar Council, the Law Society and a number of lay members. The process through which the Judicial Appointments Advisory Board recommends applicants for consideration by Government is set out in Part 5 or 4 of the Courts and Courts Officers Act 95 as amended. These applicants are those who meet the eligibility criteria for the particular course set out in the Courts Act 61, so 12 years as a solicitor and a barrister, etc. for the Superior Court. Serving judges are not currently required to apply to the JAB. It is also worth noting too that Section 18 of the 95 Act makes specific provisions that the Board may recommend the Attorney-General for appointment to judicial office. Where the Attorney-General wishes to be considered for appointment to judicial office, he or she shall withdraw from any deliberations of the Board concerning his or her suitability for that office. This is the law. By letter of my predecessor dated the 11th of March 2020, the JAB advised that they had met on the 9th of March and decided to recommend one candidate, Seamus Wolfe, whom it considered suitable for the appointment to the Supreme Court. As requested by the Minister and as required by the Courts and Courts Officers Act 95, the JAB indicated that there was one applicant considered for the post through JAB process, Seamus Wolfe. There were no other applicants. Deputies will note, however, from the annual reports of JAB that this number is in keeping with previous such processes in relation to the Supreme Court, with one application for 2 Supreme Court posts in 2019, one application in 2017, one application in 2015 from those eligible to apply through JAB, i.e. those who are not current serving judges. Under Section 20 of the 95 Act, all proceedings of the Board and all communications to the Board are confidential, so this is all of the information made available to me by that independent Board. As I have mentioned, the outgoing government made no judicial appointments other than dealing with the urgent appointment of the President of the High Court. So, following my own appointment at the end of June, I was informed by my officials of the vacancy to be filled of the Supreme Court and that the Chief Justice had written to my predecessor on the 4th of February seeking that the position would be filled as soon as possible. A draft memorandum was submitted to my office on the 6th of July 2020. The submission included details of the recommendation that had been made by JAB, expressions of interest from serving members of the judiciary and all other judges eligible for the position. The expressions of interest from serving judges were received over a number of years and retained on file for any current or future vacancies that may arise. Whether or not existing judges put forward expressions of interest is a confidential matter for obvious reasons, and it's not the practice to release information that might identify any of those judges. The practice in relation to appointments or nominations to positions made by government is that only one name is brought to Cabinet by the proposing minister. I believe that this practice is particularly important in relation to judicial appointments, as an open debate on the merits or otherwise of sitting judges, as well as others who have been nominated by JAB, would amount to a complete politicisation of the judicial appointments process, when one of the very great strengths of the Irish judiciary has been its non-political character and independence, unlike what we see in many other countries. It is a solemn duty on the part of the Minister for Justice to propose to Cabinet someone who, in the opinion of the Minister, is the best person for the particular judicial vacancy. The Government then decides, and this is exactly what happened in this case. Turning to the future, I think it's fair to say that reform of the law in relation to judicial appointments has been ongoing for some years. Under the previous government, the Judicial Appointments Commission Bill was published in 2017. It was then debated at great length in the Houses of the Oireachtas. The reforms arose from a public consultations process on a review of the judicial appointments system back in 2014. While the Judicial Appointments Advisory Board process was regarded as an innovation in its day, almost 20 years on from its establishment, it was considered timely and worthwhile to review its operation and indeed the entire judicial appointment system to ensure it reflects current best practice. The need to ensure and to protect the principle of judicial independence was a significant factor in the consultation process. This government has acted appropriately at all times through the current process, which we stand over, having adhered to the process and to the law. But this government has never believed that the judicial appointments process currently in place is as good as it should be. And that is why we built into our programme for government that we would bring forward new legislation to reform the process very quickly. It seems that we can all agree in this House that there is significant room for improvement in the current system. I am determined to lead that reform and to do so quickly. And I want to work with all deputies to make sure that the new system is future-proofed, to ensure that it meets the very highest standards that we expect in choosing our future judiciary, with the diverse backgrounds and skills reflecting the society they serve. And I know I can look forward to all of the deputies' support in this crucial task. I will shortly seek the approval of the Government for a new general scheme of a Judicial Appointments Commission Bill 2020 to provide for the establishment of a new commission to replace the Judicial Appointments Advisory Board. This will be reforming legislation. There will be ample opportunity for the House to discuss and debate what we need to do, and I intend to lead this reform to make it happen, and above all, to work in the interests of the independence of the judiciary and the public that we serve. And I trust I will have your support to bring about this at the earliest opportunity. Thank you.